Susan, you are a patent attorney and have a lot of experience working with technology companies. You're also a software engineer and a professional poker player. You do many amazing things. And I want to talk about this day, February 11th, which is National Inventors Day. It might be an arbitrary day, but it's a good time to talk about inventors and specifically female inventors. So let's talk a bit about some of the famous women. I think Marie Curie always comes to mind. When we think about women who are famous for being inventors, Grace Hopper. There are many amazing women who have created and patented incredible things. But the numbers are not as robust as we would hope. What percentage of patents actually get filed and issued to women?
The number of patent holders that are female in the United States. So overall, that's just not just the ones that are actively entering into the patent space filing applications, is only about 12%, 12 to 13%. So very low, but it is increasing. And one of the positive numbers that I'm saying is that really the barrier to entry is just that first one.
Yeah.
So once they file one, there's about a 50% chance that a woman's going that there will be a subsequent one by the same inventor.
Interesting.
Same female inventor.
Yeah, that makes sense. Once you've gone through the process once, you feel more comfortable doing it again. Okay. So 12, 13% of women are patent holders of the overall percentage of folks who hold patents. We definitely want to increase that number for sure. Let's talk a bit about the patent process. We don't want to go into too much detail, but let's say I am a woman who has an idea for something that I think is protectable. First, to break down the difference, just, again, like I'm in fourth grade, what's the difference between a design patent and a utility patent?
Okay, so there's three types of patents. There's the design patent, which you mentioned, the utility patent, and there's also a plant patent.
Oh, I didn't know that. Thank you.
Yes, very. Don't ask. That is one thing I have zero experience. There are very few plant patent attorneys.
Okay, yeah, I can see that.
But if you have some seed, it's a good idea to patent.
All right. Noted.
Primarily, the majority of patents are going to be utility patents, and those are going to be the most valuable because in general, those are what are frequently litigated in court. They're just it is a item that has a functional utility versus a design, which is an ornamental design for something.
So let's break it down. Let's give some examples. So I'm just grabbing my phone because it's in front of me. So I have this phone case, right, that like slides open and has credit card holder in it. Would that be a design patent or a utility patent?
So phone's a great example. So so you're the sliding feature, right?
Yeah.
That would be it's performing a function.
Okay.
A design patent can't have anything that's functional, right? And maybe we should talk a little bit about the parts of a patent. For something to be inventive, it has to be novel, which means it's new, and it has to be something that's called not obvious. And not obvious means that, for instance, if I put together something that was basically just taking two things that are already known, two things that are patented, for instance, or written in some kind of document that's available to the public, and I combined them and I came out with something cool and novel, we'll say. Okay. It's going to be obvious because it would have been obvious to combine. The patent office will likely reject that as saying it's obvious, because if you just take these two inventions that are already available and combine them, obviously you're going to get this result. So that's always the harder part to overcome. there's some other parts there's some other aspects with software, which I will skip over because that gets a little bit more complicated. It can't be an abstract idea. So you can't like, for instance, you can't patent, skin. You have the written description is going to coincide with your drawings. So the whole thing basically comes together and tells a story. Now, the most important part of a patent application is going to be what's called the claims section. And the claims are essentially, so if you have this is this is intellectual property. Just like property, you have boundaries, right? You have the meets and bounds of where your property line is drawn. And that's what the claims section is. It's defining the meets and bounds of your invention. And the way you're going to try to do is you're going to try to claim as much as you can. And then as you go through the process, you go through this dance where you submit your application. An examiner is going to look at it, try to see if there is what's called prior art, which is other inventions that are similar to what you're claiming. And then you're going to sort of start narrowing things down until you converge on something that you both agree on. So it's just like a negotiation, essentially. So the claims, whatever you claim has to be covered in the written description and your drawings. And so the whole thing just tells a story, and then you get to the meaty part, which is really what is the definition of this invention. This is what you're going to be looking at if anyone is ever infringing on your invention, or vice versa. You're going to see if it fits within the definition, the scope of whatever you have claimed. With a utility patent, you're going to have a lot of drawings and description that's going to relate to what the functionality of the invention is. With a design patent, you're basically going to have mostly drawings, and the requirement is one claim, which is the ornamental design for for pants. It's just going. So if I'm looking at my phone, the screen, right? The way that the screen is displayed, that the look and appearance of it, all those little boxes on, like, for instance, my iPhone, that actually is a design. I believe there is a design patent for that.
Makes sense. Yeah.
The shape of the phone would be a design patent. Now, some of the what you showed, some mechanical feature, that's going to be utility patent. Some camera functionality where you're getting an optical image that has to go through these different sensors and electronic components. If there's something unique in one of those electrical components, that would be a utility patent.
Something that you said was interesting to me, that the majority of patents are coming through companies. You worked for Qualcomm for a while. I know they have thousands and thousands of patents. In fact, when you walk into their main lobby here in San Diego, it's all over the walls.
They have a wall of patents.
Yeah. So for most of us on the entrepreneurial side of things, we don't have that big corporate structure around us to, march us through the process. Again, if I'm a woman, female entrepreneur that comes up with something that I think might be patentable, maybe a design patent or a utility patent, talk about what that process looks like and why I need to engage with somebody with expertise. Like, where are the pitfalls if I'm trying to do this alone?
There's a provisional patent, which is what you would file if you are not completely ready to go with what you've got enough to file, but you're not quite to that point where you're there. You might change some things down the road. That gives you 1 year, but the important thing is that gives you what's called a priority date. So your invention, if anybody builds anything after that date that infringes on your design, you're covered from that, from the date of filing that provisional. You have 1 year to convert it to what's called a non-provisional, and that's going to be the real deal. That's going to be the one that you're going to be looking to get a patent granted for. The reason you want to engage with someone who knows presumably what they're doing is because of the biggest reason if you may, there are a number of mistakes that can be made. There's a lot of statutory requirements, and there's a lot of, and you have to make sure that you will include everything that is important in that description, because if you don't, you can't put it in later. You'd have to start doing new filing. And if you don't, the rules are very rigid, and they're very, and there's no real, like, there's really no flexibility. If you mess up, you're done. It's not like a trademark where if for some reason you make a mistake and you forget to pay a fee, as long as you keep using it and you're still using it, you can just file a new one, and it's as good as if the day you started, with some caveats. With a patent, if you make a mistake and you let it lapse, it's done, and it becomes prior art that's used against you in a future application that you might file.
Wow.
And so that's why you really want to have someone who understands what the statutory requirements are, so that everything is, in good form, or if there's a mistake, it's fixable. And you also want to have someone who knows how to write a claim, because it's a very unique language, and it has to be you want to be very specific. You don't want to leave room for ambiguity, because that's where the millions of dollars in litigation takes place.
Yeah, absolutely. I can only imagine. And then what should I be budgeting? Let's just say I decide I want to do a new utility patent. We'll use my phone as an example. And I have a new case that I want to design. And I think that, it's novel, as you said, there's nothing else out there like it. What should I be budgeting for an engagement with an attorney to walk me through this process?
So you're going to be looking at probably somewhere around a 2 to 3 year process.
Okay.
In total, unless you need it, unless you decide you want to expedite it. The initial filing is going to probably run you somewhere. You're going to want to budget $25,000. I'd say $25,000 to $30,000 over that 3-year period.
Okay.
But upfront is going to be your biggest cost, and that's probably going to be somewhere, depending on who you go with. It's going to be, and it could be anywhere from $6,000 to $12,000 for that initial filing, plus for attorney's fees, plus the filing fees.
Yeah.
And there's a different structure depending on whether you're a small business or a large business, or even if you're a solo inventor, you can get reduced rates.
Okay, good to know, because I do run across people quite often. They're like, I have this idea, and it's like, okay, great. Just know that this is a process. It's like you said, 2 to 3 years, and this is an investment, and it's an investment in the business, the idea. And then once you get your patent, right, you still have to manufacture the product and get it out there.
You still have to, the patents are used for you can use them for a number of different purposes. So there is the protection, right? It gives you the right to exclude others from using that same product or invention, or technology. You can also use them defensively. So companies, for instance, like the biggest example is Red Hat. They make the Linux, which is an open source software program. They're not under their license. They don't want to. They are not a fan of the patent system. That's where open source software sort of came from. It was just the idea of sharing everything. But they do file a lot of patents, and the reason being is that if they're ever sued, they have a way to respond, and in a basically come out strong with, hey, you got, you say you're infringing, well, we say you say we're infringing, we say you're infringing on these patents, so what do you want to do about it?
Yeah.
And then there's also to prevent others from filing a patent. There's some groups that just have ways where you can just you can just write stuff down because you don't like patents, and you just want to make sure that no one else files.
Got it. That makes sense. Okay, awesome. Well, thank you, Susan. I really appreciate your insights, and happy National Inventors Day.
Hey, I didn't. It's the first I've heard of it. How exciting!
Yeah, exactly. We're gonna have to celebrate.
Exactly. Yeah, we'll get a cake.
Exactly. Patent that cake. No, I'm just kidding. Awesome. I love it.
Build something out of popsicle sticks.
There you go.